Welcome back, everybody, to our studies in wills and the administration of estates. We are continuing in this lesson with a number of introductory concepts and introductory ideas, this time thinking about property that may be passed outside of the instrument of a will, regardless of whether or not a will even exists. And so this would essentially be more aptly described as a video on the ideas of property that passes outside of a will, if such a will exists, or outside of the rules of intestate in the case, the rules of intestacy, should I say specifically, in the case of situations in which the will does not, in fact, exist. This is the first part of the question, or one of the first parts of the questions that we're examining from the previous lesson. If you remember back to that previous lesson, there were a number of questions that I posed towards the end of the video that is associated with the kinds of things that a solicitor might be concerned in when thinking about the ideas of an individual, thinking about dealing with property after an individual has passed away. The first question was, in fact, the question of whether or not there was, in fact, a will, and if so, was that will valid? The second question is whether or not there was any property that passed outside of that will. So, in fact, we're really dealing with the second of those questions from the previous lesson. Essentially, we noted that there are certain types of property in certain circumstances that will pass independently of the will instrument. And essentially, this is something that is completely irrelevant to the question of whether or not a will in fact even exists, what the will even says, or concerning any of the rules of intestacy. One such example of property that passes outside of and beyond the scope of the will or the rules of intestacy is the idea of a life insurance scheme. If an individual in their life were to take out a life insurance policy and pay a monthly payment towards that life insurance policy, then upon their death, as that being a condition for life insurance, a condition in which the insurance itself does what we call maturity. We call this a maturity. The insurance will in fact mature. And what that means is that upon maturing, the property will then pass to the personal representatives of the deceased. If there is a will, then that money can pass and be distributed according to the terms of the will, but the very fact that that property passes to the personal representatives of the deceased is something that would take place regardless of whether or not that will in fact existed or what the terms of that will were. It might be the case that the terms of the will might specify how that money is then distributed, but at least in terms of the actual passage of that property from the deceased or from the people who you have taken the life insurance policy out with to those representatives, that takes place outside of both the idea of the will and also the basic rules of intestacy. Again, if there is not a will, then the money will be distributed according to the rules of intestacy. More of that in future lessons. Another example of property that will pass irrespective of the will and the will instrument is property that is held on trust. So, in some circumstances, the deceased might be the beneficiary of a trust. If they are the beneficiary of the trust, then they will have an equitable interest in that property during their life, assuming, let's say, for example, it's a life trust. In most cases of property being held on trust, or in most cases where an individual is the beneficiary of a trust, when that person's life comes to an end, so too does the equitable interest that is associated with that individual. So a life trust, for example, might be such an illustration of that. So then what happens when this happens? What happens when the beneficiary dies? Well, such an instrument would then come to an end according to the terms of the trust upon the death of the beneficiary. A further example, the penultimate example for this lesson, is the idea of a pension scheme. So a pension scheme essentially exists for the most part. They essentially are set up under what we call a discretionary trust. More on discretionary trusts if you go and have a look at our lessons on trusts for the SQE module on that particular topic. But essentially, a discretionary trust, as the name suggests, gives the trustees, the people who are tasked with legal ownership and have a fiduciary duty to the beneficiaries, the trustees have a certain amount of discretion about what to do with the property that they have legal title over. When an employee dies, it is often the case that a lump sum will usually be calculated, and then that lump sum will be distributed according to the discretion of the pension fund, the trustees who are running the pension fund. Again, the reason this is property that is passing outside of a will is because this payment will be made irrespective of the terms of the will or irrespective of the rules of intestacy. And then finally, we can think about certain properties in relation to land ownership and to joint tenancies. So common ownership, where you have more than one owner of a particular type of property, will then be subject to something known as the doctrine of survivorship. So where property is owned by more than one person, and this property is owned in a joint tenancy, and where one of those people dies, then the interest in that property will then pass to the remaining tenants, to the surviving tenants, according to this basic rule of survivorship. Now, as we will note in our land law lessons, and as we have noted in the ordinary land law lessons that are not SQE focused, the doctrine of survivorship only applies to situations of a joint tenancy. And we often in land law make a clear delineation between the idea of the joint tenancy and the idea of the tenancy in common. The main distinction, one of the main distinctions between the joint tenancy and the tenancy in common, is the very fact that in one instance, in the former instance, the joint tenancy, the doctrine of survivorship applies. Whereas in the case of a tenancy in common, then the doctrine of survivorship will not apply. Again, more on this when you go and have a look at the land law videos on co-ownership of property.